Council, we're going to get ready. We're going to start.
The Supreme Court is now in session. The Honorable F. Philip Carbolito, Chief Justice, presiding.
Good morning, councils. We are now going to start our oral arguments, and I'm going to ask the clerk to please call the case.
This is Supreme Court Case CRA21-007, People of Guam Plaintiff Appellee versus Jeffrey Guerrero Cruz, Defendant Appellant. Appearing for the Defendant Appellant is Attorney F. Randall Cunliffe. Appearing for the Plaintiff Appellee is Attorney Stephanie E. Mendiola. The panel consists of Chief Justice F. Philip Carbolito, Associate Justice Robert J. Torres, and Associate Justice Catherine A. Merriman. Attorney Cunliffe reserves 5 minutes.
Mr. Cunliffe, you are recognized. Please proceed.
Mr. Chief Justice, and may it please the court. This matter involves Mr. Cruz, who was babysitting some of his nieces and nephews at their home inside a family compound. Mr. Cruz fell asleep, and one of the children, who is the victim in the 2 convictions that are on appeal, went next door to the house where her grandmother was staying, and she was able to get the attention of an auntie who came out, took her inside, saw the grandmother. The little girl wanted to speak to her parents, and the aunt made a phone call where the daughter had a conversation which the mother recorded a video of while they were driving home, and she recounted that she had been sexually assaulted by Mr. Cruz. Upon coming home, the parties were confronted, the police were called, and Mr. Cruz was arrested. The appeal now is based upon one issue and one issue alone, and that is ineffective assistance of counsel. And if ineffective assistance of counsel under the Strickland doctrine is required to show that the performance was below the objective standards of reasonableness, and if that occurs, then also that the defendant was prejudiced. In the case, one of the questions and one of the issues that has come up, of course, is that Mr. Cruz was acquitted of a number of charges. So how was his behavior below the standard of reasonableness? Well, I would like to phrase it as, is a lack of a strategy a standard? And it is clear from a review of the transcript that the trial counsel had no strategy at all in this case. I think it was, let's throw everything up against the wall and see if something sticks. What did he do in the trial? He didn't ask the victim any questions about the incident. He didn't ask her any questions about the phone call to her parents. He attacked the parents as being drug users, abusive, violent, and manipulative. He attacked the prosecutor. He was reprimanded by the court about his behavior at least 5 times, including told him to keep your mouth shut, you just be quiet, no comments from the peanut gallery, and that he was bragging also.
What about the contention of the government, Mr. Cunliffe, that the same I guess it's reference as to his approach, maybe not strategy, his approach applied to all the other victims in terms of not being cross-examined as to the sexual acts, blaming the parents and that they're liars and drug addicts, and they were just, the strategy is that they were in some way influenced by the parents to, I assume, make these allegations. And he was successful in the other victims in terms of the same approach. And so how is it that now, I guess in retrospect, because the results did not materialize as to this one particular victim, KTC, that that he did have some success in the trial, and that he did have a plan you don't want to call it a strategy. So we'll say he did have an approach that he applied across the board in reference to the other victims, and was successful in that regard. So how can the government saying, how can you say that he was ineffective?
Well, Your Honor, to use an old phrase, even a blind squirrel can find an acorn once in a while. And in this situation, you know, I can't delve into the mind of the jurors. And I know that, you know, Justice Merriman spent a long time on the trial court and was probably as perplexed as defense counsels and prosecutors as to some decisions that juries made. But let's look at this as you've postulated it, Your Honor. The recording, which was admitted by stipulation, contained corroboration of the statements of the girl who was upon whom the convictions rest. There was no corroboration of anyone else's statements, any of the other children's statements. They had never made the allegations in a timely fashion. They were 2 years, 3 years, 1 year, 6 months old, whereas this was a contemporaneous situation. The fact that the parents were violent, drug users, manipulative, still didn't establish that they had an opportunity to even discuss the matter with the children before they were interviewed and made these allegations. So, I mean, I can't answer that, Your Honor. I mean, I was flabbergasted that he got the verdicts that he got. And I can only say that, having tried a number of cases myself, that sometimes, you know, jurors do want corroboration. And when there's old statements made, allegations made that are 6 months, a year, 2 years old, have never been made before until this comes out, they just may not believe them without corroboration. And that leads me to the stipulation that was admitted. It was the only evidence of count 7, which was the touching count. When the victim testified, she never mentioned that he had her touch his penis with her hand. So by stipulating, he brought in the only evidence of conviction of one of the 2 counts against the defendant. His closing argument.
Mr. Cunliffe, what about the argument that the recording could still have been admitted under the excited utterance hearsay exception? So when the stipulation was made, it was before she testified, and the government argues that a reasonable attorney could assume that she would testify as to both counts, and so it wouldn't give any information that the jury wouldn't already hear from her. As well, it potentially could have been admitted as an excited utterance.
Well, the argument that was made and how the matter actually occurred was, while he agreed he was going to stipulate to it, it wasn't going to happen until after she testified, because he claimed there was a confrontation clause issue. So it didn't come in until after she testified. It wasn't played for the jury until after she testified. And the government can say, well, the judge would have allowed it in as an excited utterance, but he didn't. It didn't come in as an excited utterance. It was never argued. And if the judge had said, no, it's not an excited utterance, it wouldn't have come in, and it wouldn't have been a matter for this court to decide.
But if in evaluating the 2-pronged test, I mean, if we say, okay, his performance was deficient in stipulating to the recording's admissibility in advance of her testimony, even though it was played after her testimony, because I think he stipulated in advance of her testimony, correct?
He stipulated that he said he would stipulate only after she testified. He wanted her to testify before he stipulated.
So the stipulation was after she testified. That's your position.
Yes, he said he would do it, but he didn't do it until afterwards.
Okay, and so if we assume that his performance was deficient, then we have to evaluate whether the deficient performance prejudiced him to result in a denial of a fair trial. And if the recording did qualify as an excited utterance hearsay exception, how would your client have been prejudiced by its admissibility?
Because one of the counts of conviction was only contained in that stipulation. It wasn't testified to otherwise.
But I think the argument, Mr. Cunliffe, is that I understand Justice Torres is trying to emphasize here is that in us deciding whether or not the apparent alleged deficient performance caused a prejudice, and although I understand that our argument is that the trial judge did not decide in the first instance, make the evidentiary ruling whether this would have, the videotape would have come in under the excited utterance exception to the hearsay. In us making this analysis of whether there's prejudice, we have to, or we then will then have to make that determination in reference to whether or not this videotape would have come in. While just in addressing the prejudice issue, although we understand that the evidence came in under a stipulation, the trial judge did not make a ruling in order for us to reach the prejudice or analyze the prejudice issue is with the videotape under the circumstances that it was made qualified under the excited utterance ruling. How would we apply that law or that exception in order for us to determine whether or not the videotape would have come in or not? And I don't think we can just ignore and say, well, since the trial judge didn't make that ruling, we're not going to do it, and so we'll never know. To me personally, in deciding whether or not there is prejudice, I would have to see whether or not the circumstances in which the videotape came in or could come in does qualify for this exception to the hearsay rule.
Well, Your Honor, what the court is describing now is making a ruling on something that wasn't ruled upon at the trial court. And I just don't know how an appellate court can do that.
I don't know if I would say making a ruling. I say that in order for us to, in order for me to determine if there was prejudice, I would have to analyze the argument and decide whether or not those circumstances could have been satisfied. I don't think it would have made a determination that yes, this evidence should have come in under the excited, or would have come in under the excited utterance. I don't know if I would go that far, but I wouldn't stop and say because the trial court didn't make the ruling, I'm not going to examine in my mind whether or not the evidence could have come in order for me to determine whether there is any prejudice or not. Because if we don't make that analysis and there is no determination if this could have come in under the excited utterance exception, then you're correct. There is no evidence that the facts were satisfied that the victim here touched the penis of the defendant. And there would be no evidence of that. And that's, of course, the count that he is being charged with. And so an ineffective assistance of counsel determination, we need to determine if the deficient performance prejudiced the defendant. And if we just stop and say, well, no, the government's argument that this would have come in any event under the excited utterance, just because the trial court didn't make that ruling, that leads to a conclusion. And I don't think I don't see any cases cited that we can't make that determination, not for the purpose of deciding whether the evidence is admissible, but in my mind, for the purpose of determining whether prejudice occurred to the defendant in this case.
Well, Your Honor.
Mr. Cunliffe,
Yes,
Is there
ma'am.
enough information in the record for us to even consider that issue? Seems to
That-
me there's a lot of missing. Because it wasn't argued in the trial court, we don't know how the recording was made. We don't know when these statements came in. We don't know if the parents were pressuring her. Can we even address that issue?
That was the point I was going to respond to the Chief Justice on, Your Honor. The court and myself have a transcript to review. I don't have the police reports. I don't have the discovery. I don't know what argument could have been made to address the issue of whether this was an excited utterance or not. Things that might have been able to come in that would say it's not an excited utterance. And so I don't think the court can. And I don't know how the court could say, well, based upon what's in the record, we think it's an excited utterance because.
Well, then aren't you suggesting then that we don't have a record that we can make this determination? Because you contend in your brief that the record is sufficient for us to make a determination of ineffective assistance, and it's not a case that normally should go as a habeas corpus in order for the evidence to be developed and in order for there to be a determination. So what you're suggesting to me now is that we don't have a record that is developed enough to make this finding.
I don't think that when a trial judge doesn't have a motion or made in front of him to admit something as an excited utterance, when that is never made, and the arguments are not put forth to the court as to why that would be an excited utterance, that the court, an appellate court, could come forth and say, well, from the record we see, it could have come in as an excited utterance because we don't know what the trial court would have done. If it had brought to the trial court, what if the trial court had said, no, it's not an excited utterance? It wouldn't be an issue for you to be even try to resolve. He would have been acquitted of the touching count, and he may have been acquitted of the other, but the government can't appeal that decision.
But isn't it a de novo review as to whether or not ineffective assistance occurred here? And it would be a mixed question of fact and law in reference to the admission of the evidence. And in doing a de novo review, we can review the record.
Well, my point, Your Honor, is that because it wasn't raised below as an excited utterance, this court has no business deciding it's an excited utterance.
But you haven't cited any case to that effect. If you have a case authority that says we are prohibited from determining whether or not in analyzing the prejudice issue, since the trial court didn't decide in the first instance whether the evidence was admissible, then the appellate court is foreclosed from also reviewing that issue in determining whether there's prejudice. I didn't read any case cited to that effect.
But the trial court didn't have to rule. That's my whole point. They didn't have to rule whether it was an excited utterance because he stipulated to it.
I fully understand that. I give you that. That if
So
if
whether
that,
it's excited utterance or not doesn't matter because he stipulated to it. And we can't now go unring that bell and say, well, let's go decide whether it's an excited
but
utterance.
that goes to the first prong, whether or not the performance was deficient. I think just Storis points that out, that if he stipulated and the circumstances that he probably should not have done that, and that performance was deficient. But then the second prong is, was the defendant prejudiced as a result of that?
Well, in the case that was cited by the government, the Coleman case, what they took the one section that said, by merely stipulating is an ineffective assistance of counsel. In the Coleman case, the stipulation was incorrect. The amount of drugs in the Coleman case was less than they actually stipulated to, so he got punished. And they found that is error. Well, in this case, he stipulated to allow in evidence which convicted him of one count and corroborated the testimony for the conviction in the other count.
Yeah, but the difference is one is in reference to the actual evidence result. The difference that I see in this case is the effect of the stipulation. It's as a result of the stipulation, there was certain evidence that was allowed in. In that particular case, it was an erroneous evidence. It was an erroneous stipulation. Instead of 70 grams of whatever the drug was, it was only 7.02. So, there was an error in the stipulation. And that was the ineffective that resulted in prejudice to the defendant. I think there's a distinction there in reference to the result of the stipulation that resulted in the ineffective assistance of counsel determination.
Well, in both cases, there was a conviction based upon what was contained in the stipulation, and the conviction would not have occurred if the stipulation had not taken place.
But if the evidence was admissible, for a different reason other than on the basis of the stipulation, then wouldn't that impact our analysis of whether there was prejudice? And so maybe the idea is, well, we don't know if it was or wasn't admissible for other purposes, so the record is insufficient for us to make a complete determination that the deficient performance prejudiced the defendant to result in the denial of a fair trial. I mean, you had argued that the record in front of us was complete for us to be able to make the determination of ineffective assistance on the record. But if we do agree that the counsel's performance was deficient in stipulating, we still have to determine the prejudice of that stipulation. And if the evidence that was stipulated to would otherwise have been admissible, then I think that does impact the analysis of whether he was prejudiced.
Whether the evidence was otherwise admissible was a decision for the trial judge to make. And
we understand that, and we understand that.
But I don't believe you can substitute your opinion for an opinion that the trial judge didn't make.
Mr. Cunliffe, are you saying that the standard of performance for a defense counsel is to always object to the admission of evidence if it's as critical as this is, or at least put the government to its burden of admission?
No, Your Honor, I'm not saying that. Obviously, in trials, we make strategic decisions all the time. In the trial transcript, the trial counsel said, when the prosecutor said it's admissible as an excited utterance, he said, no, it's not. So his position was it wasn't admissible as an excited utterance. He said he wouldn't stipulate to it unless she testified, because there was a confrontation clause issue. So he didn't stipulate to it until she testified. But once she testified, and she didn't testify about the touching incident, he was stipulating to bring in the only evidence that would convict his client of that charge.
So at that point, his duty was to argue it wasn't admissible somehow.
Or try to limit its admissibility to what she had testified to in court.
And that would be the standard of practice in that situation.
Well, Your Honor, I mean, quite frankly, I've never seen a transcript like this before in my life, and I've been doing this for quite a long time. I was astounded. I mean, at his performance, and I mean, you can't even understand his closing argument. He made comments like the video is insane. The video shows so many things that aren't right about something. I mean, but
and it wasn't a video anyway, right? It was a.
I'm sorry, Your Honor.
It wasn't a video. It was an audio recording.
No, it was. She actually video. I think she videoed the other phone screen, I think, is what happened.
Okay.
But yeah, I mean, that's my point, Your Honor. When the judge below didn't make a decision, I don't know how an appellate court can decide for him what he would have done. And that's why I say you can't reason back to the excited utterance, because there was no decision at the trial court. If the trial judge had said it's not, there's nothing before you.
But if the trial judge had made the ruling that it qualified under an excited utterance exception, and defense counsel on appeal says the judge was mistaken, we would be able to review it. And
That's
here we would be able to review it based on the presentation, the facts and the evidence and the circumstances, not because the trial judge said it was admissible, that we would arrive at a conclusion. We would arrive at a conclusion, a decision based on the circumstances and the tests to decide whether the evidence comes in under the exception of the excited utterance. And so the problem I'm having in my mind is that why can't we do that analysis for the purpose of determining prejudice, not for the purpose of determining whether or not the evidence could have been admitted or not, or that the trial judge, what decision the trial judge would have arrived at, and whether it was he was mistaken in reference to its admissibility. It to me, again, I just go back, it goes to the issue of prejudice. And that is clearly in front of us in an ineffective assistance of counsel claim under the second prong that we must analyze. I see you have 4 minutes remaining, Mr. Conliffe. Do you want to reserve your remaining time?
Yes, Your Honor. Thank you.
Thank you, Mr. Conliffe. And Ms. Mignola, you are recognized.
Dismasi, Your Honor. Mananacitus, Mr. Chief Justice, Justice Merriman, Justice Torres, and may it please the court. On the contrary, Mr. Cruz's trial counsel was not deficient because he zealously advocated for Mr. Cruz by deploying an objectively reasonable trial strategy, and we can call it a strategy over an approach. And two, that advocacy produced a reliable outcome in which Mr. Cruz was acquitted of 6 of 8 criminal sexual conduct charges, as opposing counsel mentioned. Throughout his trial, Mr. Cruz received the exact type of effective assistance of counsel as guaranteed to him by the 6th Amendment. And for these reasons, we ask this court to affirm his 2 convictions. Trial counsel's strategy was to cast doubt on Mr. Cruz's guilt by pursuing the very common CSC defense theory that the children fabricated their allegations. In this case, at the direction of their parents, who trial counsel characterized as abusive, controlling, manipulative, dishonest drug dealers.
Can we talk about the recording, the video recording? The government stated that trial counsel's stipulation was, first of all, in one part, they said it was conditioned on the victim testifying and was part of trial counsel's deliberate strategy. And then also indicated that it was an effort to ensure that they could use it for impeachment purposes against the victim when she testified. So first of all, I don't understand the argument that the stipulation would have been conditioned on the victim testifying, because the defendant has the right to confront his accuser. And so why would the stipulation, the condition of the victim testifying, be a condition of the stipulation?
It wasn't a condition of the stipulation, Your Honor. What the record will show is that it was what was discussed in terms of what could have been conditioned upon, what the stipulation could have been conditioned upon at all, was the timing of whether the video was admissible. Admitting the video was a part of counsel's trial strategy, and there was extensive discussion of how he intended to use the video in support of his strategy that not only included impeachment of the witness or to determine whether there would potentially be inconsistent statements, but also the video recording included comments made by the parents, and he needed to characterize the parents as part of his very reasonable trial strategy.
Yeah, but if you look at your opening brief, and on page 8 of your opening brief, you specifically say, although there is not and you cite to supplemental excerpts of record 4 and 8, it says a review of the trial transcript shows in the first full paragraph shows that the trial counsel's stipulation was conditioned upon the victim testifying and was a part of trial counsel's deliberate strategy. I mean, those are the words of the Attorney General's office. So are you saying that that's not what they meant when they wrote that?
Not that it wasn't conditioned only upon the victim testifying, but the exchange on the record was centered around whether or not the victim would testify. And it was more so that trial counsel was focused on the video coming in and him not being able to use the video to counter what the victim might have said. And so it goes more.
The argument. Okay, I'm sorry. Go ahead. You can complete.
Oh, just not that it was completely wrong, just that the focus of trial counsel was on the timing of when the video would be admitted relative to the victim coming in to testify.
All right. And
sorry, Your Honor, go ahead.
You made the argument, I guess, as well, that they intended to use the recording for impeachment purposes of the victim, right? Is that accurate?
Among other things, yes.
Right. But yet, when the victim testified and did not testify as to the sexual contact charge, he did not use the recording for purposes of impeachment. He didn't cross-examine her on that.
He did not, Your Honor.
Yeah. So it seems like if his strategy was to use it for impeachment purposes and then didn't use it for impeachment purposes, it seems somewhat contradictory. I mean, one would think that if he's stipulating for its admissibility, for understanding its value for impeachment purposes, and then doesn't use it, that doesn't add up to me.
It wasn't only impeachment of the child witness, Your Honor, the child's victim, Your Honor. It was also impeachment of the parents. In the exchange about whether or not to admit the video, trial counsel also mentioned, in addition to wondering if the child would make the same statements in the video as on the stand, he also addressed that it was his intention to bring the father in to address the video, and that he would specifically, his plan was to cross the father as a hostile witness and use it in that manner as well. So it wasn't only for the child's victim.
Now, Mr. Cunliffe pointed out, and I want to know if you agree with it, that the stipulation wasn't actually entered until after she testified. There was discussion about stipulating, but it wasn't stipulated till after she testified. And so when she testified and did not testify as to the sexual contact, why would you want to admit this recording that contains the only evidence in the trial of the sexual contact?
Two things on that, Your Honor. Why would you want to admit what might otherwise be harmful to your position? Because if it is part of trial counsel's judgment as an attorney to decide whether or not that admission would be worth him being able to use the same piece of evidence to support his overall strategy, which was aimed at total acquittal, which he nearly accomplished in this case. But if I actually wanted
why couldn't he move to, as Mr. Cunliffe suggests, limit the recording to only a portion of the recording and not include the evidence of the sexual contact?
One, because he needed the entire recording and couldn't only limit it to the child victim's statement in support of his theory. But Your Honor, I also wanted to correct that the record actually reflects that the video was not stipulated after the child testified. The video was not entered after the child testified. The video was stipulated to before the child's victim came on the stand, but it was admitted during her testimony. And in the discussion with opposing counsel, there was extensive discussion about whether or not it would have been admitted as an excited utterance. that's very much well within this court's authority to analyze. But even before that, procedurally, what's on the record, aside from the stipulation, is that the recording was actually entered as the video was actually admitted through the witness as a recorded recollection. So as the chips fell, however the timing of the trial played out, the admission actually happened during an exchange between the prosecutor and the child, because the child needed her recollection refreshed when discussing the conversation. So procedurally, it would have been admitted that way if it wasn't stipulated, and it definitely would have been admitted as an excited utterance because it meets all of the elements. In recognizing that opposing counsel is arguing that this court shouldn't analyze that because the trial court didn't, one, there isn't any authority that eliminates the appellate court's or a reviewing court's ability to do that. On the contrary, in several cases, there is in fact the reviewing court doing exactly that in order to determine the second prong of the Strickland test being prejudice, as was discussed earlier. So here, the people submit that the stipulation was not deficient because it was certainly a matter of trial strategy, which is well established on this record. And second, even if somehow the court does not extend the deference to trial counsel in executing the strategy and finds that it was deficient, it certainly wasn't prejudicial. That evidence would have come in any number of ways, whether it was as a recorded recollection, as an excited utterance, possibly even present sense impression, a number of other hearsay exceptions, arguably, depending on if there was no stipulation and how the trial proceeded, depending on what defense counsel did, it could have even been brought in, as not hearsay if it was a prior consistent statement because the child testified as a witness. Aside from all the exceptions of admitting the video, if at the end of the day, the video was absolutely barred from admission after all these different avenues were considered, then presumably the government, it's very safe to assume the government would have changed course and figured out a different way to get in what was otherwise the only piece of evidence to support count 8 or count 7 of the indictment. So the stipulation was not deficient performance. It was a matter of reasonable trial strategy. It was a very specific strategic decision supported by the record. That decision is owed great deference. As a matter of law, it's presumed to be sound trial strategy. But even somehow, if it weren't, it was not prejudicial to the defendant. The outcome on this particular charge would have been the same. And on that point, I would also just like to segregate the two charges that defendant was convicted of, because the video referenced 2 of the sexual acts, both of which the defendant was convicted of. But on the stand, the victim testified to 1 of the 2 acts. So at issue is whether or not it was deficient for counsel to stipulate to the recording, given that it was the only piece of evidence other than the we'll just call it count 3 and count 7. If this court were somehow to find deficient performance, we ask that this court limit it, deficient performance and prejudice somehow, we ask that this court limit it only to count 7 and not to count 3. That being said, the other issue that opposing counsel raised in deficient performance that was arguably deficient performance by opposing counsel was his decision not to cross-examine the witness, of course, as it ties into the discussion of whether or not the video stipulation was entered. The stipulation to the video, was agreed to. And it is our position that failure to cross-examine a child about specific sexual acts is also not deficient performance. Not only is it a reasonable strategy, but it is a very common strategy for defense counsel to use to avoid attacking a young child on cross-examination in front of the jury. And that was the very decision that this trial counsel made. He did not have to cross-examine the witness to undermine the allegations, because he already knew he had stipulated to the video admission, and he didn't need to as part of his overall strategy to discredit the children. He was primarily focused on attacking the parents and presenting evidence about the character of the parents, about presenting evidence about how the defendant was well loved. As opposing counsel mentioned, on a few occasions, he was attacking the prosecutor. He was argumentative with the court. All of this was part of his overall strategy to deflect blame on Mr. Cruz and to cast doubt on his guilt. And it worked in a majority. It worked. It was a strategy that worked. And it was the majority of the charge. He was acquitted on a majority of the charges. Additionally, if he was not, that goes to the first point of the first prong of Strickland being met, that it wasn't deficient not to cross-examine the child. But even if it was, again, there is still the prejudice element. And even if he did attack her credibility, which is what he was trying to avoid, and did alienate the jury, the outcome would have still been the same.
Now, Ms. Minjoli, you focus on the overall results of the trial, and you characterize, and there's a certain appeal to that. You know, how can anyone argue ineffective when he was acquitted in 6 of 8 charges? But Mr. Cunliffe's argument is focused on count 7. He could have been acquitted on 7 of 8 charges had he done his job properly and not agreed to that stipulation, because that was the only evidence that produced the evidence that satisfied the elements of count 7. And so just focusing on that particular charge and the handling of that and producing the evidence that ended up convicting his client, that would seem to satisfy the Strickland elements. And if we were to look at it as a focus argument and not the overall results of the trial, I mean, is that what we're supposed to do in reference to the ineffective assistance of counsel charge? And the argument here is not as to the entire trial, it's just as to this one count.
Sure, Your Honor. No, what a reviewing court is not supposed to do is to focus on the specific outcome. The court is supposed to review the overall performance of counsel, consider all of the circumstances at the time that counsel was making his decisions about trial strategy. And ultimately, the analysis is to focus on whether or not counsel functioned as the type of counsel guaranteed by the Sixth Amendment, that is fulfilling the role of the advocate that would test the limits of the adversarial process when a defendant is before the court. So the analysis is focusing on counsel's overall performance. That the challenge here is focused on one specific act and one specific outcome. First, again, we just submit that the stipulation wasn't deficient and that it wasn't prejudicial and therefore doesn't meet the standard of ineffective assistance of counsel. But furthermore, even focusing on that specific outcome, we're doing so in hindsight, and the reviewing courts are cautioned against looking at specific bad outcomes as a determinative factor of whether or not trial counsel executed a competent and professionally reasonable strategy in representing his or her client. So to summarize the answer to your question, no, we don't. We can analyze the specific act, which the defense is required to specify, but we don't look at the specific outcome or analyze the specific outcome. We analyze the overall performance. Thank you, Your Honor. One moment, Your Honor. The final argument that that Mr. Cruz takes issue with in arguing that his counsel performed efficiently was his closing argument. And of all the, I suppose in sounding like a broken record, trial counsel strategy was wrapped up in his closing argument, as setting aside whatever we may think of it or that we may have done it differently. His closing argument encapsulated all the things that he was trying to address throughout the trial in vigorously advocating for his client. And closing argument is probably arguably the place in the phase of the trial where there is the widest range of latitude for how counsel will approach addressing the jury, subject to certain rules. But counsel's that opposing counsel would have approached closing in a different way, or this trial strategy in a completely different way, or maybe even the same strategy in a very different way, doesn't render Mr. Cruz's trial counsel's strategy as constitutionally deficient. So that said, there being no deficient performance by counsel in stipulating to the audio video recording, no deficiency by counsel in failing to cross-examine the young child victim about the specific sexual misconduct committed against her, and no deficient performance in the way that he gave his closing argument. We ask this court to find that there's no inefficient assistance of counsel, and to affirm his convictions.
All right. Thank you, Ms. Mendiola. Any other questions for Deputy Attorney General Mendiola? There being none, Mr. Cunliffe, you have a little over 4 minutes remaining to complete your arguments.
Thank you, Your Honor. Your Honor, I agree with the government that if the court finds that his performance was deficient, the court would have to reverse his conviction entirely and not just one count. The arguments that the government makes, they said definitely would have been admitted. They said it would have come in a number of ways. Now, I think the proper terminology it may have come in, but the trial court heard no arguments that it could make a determination whether it would come in, and therefore there's nothing on the record for this court to determine whether it would have come in, because the trial court never had to make that decision because it was submitted as a stipulated to. And Justice Torres, I think the conversation that took place as to when the tape was going to be admitted is on pages 30 through 32 of the defendant's appellant's excerpts of record. And the discussion, basically, he says, I'm not going to object to it, but I don't want it to happen now. I don't want to admit it now. And then on the bottom of page 31 of the thing that he doesn't want it to come in and try to get around a hearsay argument if he brings it in before the young lady testified. But other than that, Your Honors, I believe that you understand my position, and I have nothing further unless there's other questions.
Just a point of clarification, because Ms. Mendiola doesn't have the opportunity to clarify. I thought her argument in reference, if the court does find ineffective assistance, that the government's requesting that it be limited to count 7. And I understood you to say that you agree that if we find ineffective assistance, it is as to the remaining counts. I just want it clarifying for you to clarify, do you agree that if we find ineffective assistance, the government says it should be limited to count 7 because that's your argument, that was deficient performance and not as to count 3? Mr. Cunliffe.
Oh, I'm sorry, Your Honor.
Yeah, that's her question.
Because while she made that statement initially, then she came back and said that you look at the entirety of the case, and it's not just one issue that you look at and whether it's deficient or not deficient. I mean, my understanding, if the court finds that his presentation was didn't meet the standard of Strickland, then the client is entitled to a new trial. And it would apply to the entire trial and not just the issue of the count 7. As I indicated in my argument earlier, the jury may have felt that because there's no corroboration of the other charges, they weren't going to convict those, and the only corroboration of the charge 3 was the video or the tape that was played. So they may have decided that based upon the fact that she said it to her mother, and then she said it in court, that it's corroborated, and she would then convict him of it. But I believe it's all or none, Your Honor.
And Ms. Vignola, just for a point of clarification, do you agree with Mr. Cunliffe?
No, Your Honor.
That's what I thought. I just wanted to clarify. I think I understood your position, and I surely understand Mr. Cunliffe's position now. All right. Thank you, counsels. The court will take the case under advisement, and we now stand adjourned.
Thank you, Your Honors.